Well, hello, everybody. It is I, your generous host, Elohim the Yellow, and I hope you're prepared to hear gratuitous, explicit language as I read the first three court documents filed in Tulsa, Oklahoma of RBT versus Graves with extreme prejudice. Stay tuned. Hello and welcome to Hood Melon Culture Studios. Today we're going to be going over court documents and the order in which they were filed. The first one is hefty and long, and I know some of you people have been like, oh, well, if it's Thomas isn't proven in court. Well, I mean, that's not how patent infringement works. When you're the owner of a patent and someone else infringes on you and then they sue you because they filed a patent which is already your patent, and they say you're infringing on them, you don't have to prove shit. At least you shouldn't have to. Pardon my French. But when you have let's say a $30,000 like RV mobile home just sitting out in front of your driveway, and you have a freaking crazy, freaking hopped up, Breaking Bad neighbor that lives, down the street from you. And he was like, oh man, I'd love to take that freaking nice RV out to the desert and break bad in it. He comes along, he freaking steals the RV out of your driveway, puts new license plates on it, and then registers it as his. Now, in that situation, the obvious thing to do is to call the sheriff department. The sheriff department goes out there, gets your shit back, and arrests the dirtbag. Now then, why can't we just have something that simple set up for patent infringement lawsuits, especially with rarebreed right now, where they just stole the shit right out of Thomas's driveway, and now they're parading around like it's their own, and then they started the lawsuit against Thomas, even though Thomas is the rightful owner and inventor of the technology. Then this is the first document filed 030822. What is that, March 8th, 2022? In the United States District Court of the Northern District of Oklahoma. Rarebreed Triggers, LLC, a North Dakota limited liability company, and ABCIP, LLC, a Delaware limited liability company. Plaintiffs versus Thomas Allen Graves, an individual. Powered by Graves Incorporated, which has nothing to do with Thomas except that his name is in there. Powered by Graves is a doing business at DBA started by Anthony McKnight. Alrighty then. Valor Manufacturing, Valor Arms LLC, defendants. Now, the only person on that list that shouldn't be there is Thomas Allen Graves. He's the inventor of all this technology. Frickin' This doesn't make any sense. It's just another BS strategy by Rarebreed to try and confuse the court and everybody else. Now then, complaint for patent infringement. This is an action for patent infringement in which Rarebreed Triggers, LLC, Rarebreed, ABC, IP, LLC, ABC, collectively plaintiffs, accused Thomas Allen Graves, powered by Graves, Valor Manufacturing, and Valor Arms, collectively, of infringing U.S. patent number 10514-223, the 223 patent. Even though the 223 patent I think was filed or made by one of the Round brothers, which got the technology from Thomas Allen Graves in a private conversation. It is still Thomas's intellectual property, rightfully Thomas's intellectual property. It was an idea that they were talking to him and they wanted to make the original FRT triggers like this, but Thomas said, that's a bad idea. Here's all the reasons why we aren't going to make them like this. And then Thomas licensed to them the correct way to do it, while this is still Thomas's intellectual property and his brainchild. But one of the Round brothers, I forget which one exactly it was, it might have been Junior, it might have been the other one, decided to file the 223 patent, and then after he filed the 223 patent, he infringed on Thomas Allen Graves' patent, and then he licensed the 223 patent to Rarebreed Triggers. Now then, parties. Rarebreed is a limited liability company organized under the laws of the state of North Dakota, blah, blah, blah. ABC is a limited liability company organized under the state of Delaware, blah, blah, blah. Upon information and belief defendant, Thomas Allen Graves is an individual residing in and around Sand Springs, Oklahoma. Yep. Powered by Graves is a corporation organized under the laws of the state of Oklahoma, registered at 2461 Stoneway Creek, Medford, Oklahoma. Upon information believed to Valor Manufacturing, blah, blah, blah. These are the actual infringers. Jurisdiction and venue. But it's weird for, see, okay, another thing. It's weird for Rare Breed Triggers to be suing Powered by Graves, considering Powered by Graves is a part of the company that originally licensed the 223 patent to Rare Breed. So, how does that make sense? It doesn't. But, this is what we're in right now, so... Upon information and belief, defendant Valor Manufacturer limited liability. Upon blah 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 blah. This is an action for patent infringement arising under 35 U.S. Code 271 AV 281 284 85. This court has subject matter jurisdiction over this action. Yes, while listing all the nonsense. Yes. Personal jurisdiction on defendant's property. Yeah, venue is property. Yum. Background. The lawsuit asserts infringement of the 223 patent. A true and correct copy of the 223 patent is attached in hereto as Exhibit 1. ABC is a current assignee and owner of all right, title, interest in the 223 patent. Bullshit. This assignment has not been recorded at the United States Patent and Trademark Office, the USPTO. Rare Breed has exclusive license and right to sell products covered by the 223 patent. Bullshit. Upon information and belief, defendants have committed acts of patent infringement. Bullshit. Thomas Allen Graves can't infringe upon the patent, which will be described in more detail below. These acts are in violation of 35 U.S.C. 271 and should be considered willful. The plaintiffs and defendants operate in the firearm industry. The plaintiffs are responsible for developing the first commercial force reset semi-automatic trigger. Bullshit. Thomas Allen Graves is responsible for developing the first commercial force reset semi-automatic trigger. Including the Rare Breed FRT-15 for use in an AR-15 weapon platform. The FRT-15 trigger is one embodiment of the 223 patent's invention. For the entire time the FRT-15 has been marketed and sold by Rare Breed, it has been marked with a patent notice complying with 35 U.S.C. 287. The patent number is engraved on the product and displayed on the packaging shown below. The Rare Breed FRT-15 trigger was first introduced to the market in December 2020. It is not unique, being the only hammer force reset semi-automatic trigger on the market and exclusively protected by the 223 patent, which is more bullshit. The unique FRT-15 trigger created a new market for the product that did not exist before. More bullshit. The FRT-15 trigger has been subject of much publicity, consumer interest, and vigorous sales. That part is true. Defendants are responsible for misappropriating plaintiffs' proprietary technology and selling it as their own in direct competition with Rare Breed. That part is bullshit. On August 30th, 2021, counsel for plaintiffs sent a cease and desist demand letter to defendant Graves informing him of the 223 patent and expressly accusing him of patent infringement. Even though, alright, so what Graves told me when he received this cease and desist letter, he ignored it because it's total bullshit. The plaintiff, and also on August 30th, 2021, is when Rare Breed Triggers announced to Thomas Allen Graves that they are technically the ones infringing on his patent, not the other way around. On November 18th, 2021, counsel for plaintiffs sent a cease and desist letter to Valor Arms LLC, an entity owned and sharing address of Valor 223, especially accusing blah, blah, blah. On or about February 25th, 2022, defendants began offering the Powered by Graves Alamo 15 trigger, the infringing device, quote unquote, pictured in paragraph 50, below for sale. Now, alright, so this, the Powered by Graves was originally, I think, what's it called? I don't know if it was originally the PBG and then they changed it to the PBG afterwards, or if it was this and then they changed the name. So I'll have to go over my notes and give you more updates on that. But still, it's not the infringing device because, what do you call it? Friggin' originally the Powered by Graves device, which was going to be licensed to Big Daddy Unlimited through Thomas Allen Graves, and then Big Daddy Unlimited, more or less, is the one that frickin' licensed the trigger in which they have the patent for to rare breed. It's a clusterfuck of misinformation, and unless you say something about it, you're just gonna believe everything rare breed is saying, and they're gonna be freaking eating right out of the fucking slaughterhouse's hands. Alrighty then. Graves was issued U.S. patent number 9568264, issued February 14th, 2017, and 722 issued November 4th, 2017, the FlexFire technology patents for what he called FlexFire technology. FlexFire technology patents disclosed a trigger reset mechanism in which the gun's bolt and not the hammer reset the trigger. Wolf's Tactical found Graves' FlexFire technology not readily adaptable to the AR platform. That's more bullshit. So a new invention, not a new invention. This is the part. Okay, Jeffrey Cooper Rounds from Wolf Tactical, aka Big Daddy Unlimited. All right, so Jeffrey Cooper Rounds. I say also known as Big Daddy Unlimited because Wolf Tactical and BDU have been in cahoots, and then they freaking went into cahoots with Rarebreed, and it's just been one mega conspiracy to fuck Thomas over and take everything that he has. But yeah, so the old invention was not made by Jeffrey Cooper Rounds because Jeffrey Cooper Rounds got the idea to make the said invention for the 223 patent from Thomas Allen Graves himself personally. So it is still Thomas Allen Graves' proprietary technology that went to create the 223 patent in the first place. I mean, so a new invention bullshit was made by Jeffrey Cooper Rounds bullshit or Wolf Tactical that used the movement of the hammer rather than the bolt or bolt carrier to reset the trigger in combination with a locking bar that keeps the trigger from being pulled again until the action returns to battery. The bolt carrier, the bolt reclosed, the battery open position. The new invention is embodied and claimed in the 223 patent, which was assigned to Wolf Tactical. Although not limited to use in an AR platform or AR pattern firearm, it is readily adaptable thereto, including as a drop-in trigger assembly. Wolf Tactical assigned the 223 patent to Rarebreed, who assigned then it to ABC. Later, Graves was issued U.S. patent number 9939221, issued April 10, 2018, entitled FlexFire G2 Technology. This patent resulted from a continuation in part application filed 13, 2017 after the priority date of the 223 patent. The FlexFire G2 Technology patent also disclosed a trigger reset mechanism in which the gun's bolt and not the hammer reset the trigger. On January 31st, 2018, Graves granted Wolf Tactical, LLC, of Buda, Texas, an exclusive license, the Graves license, to these patents, U.S. patent number 264, 722, and 221, to develop, manufacture, make, use, offer for sale, import, export products covered by the patents for AR pattern firearms. Thus, Graves would be precluded from making, using, selling, or offering for sale a device covered by the Graves FlexFire technology patents or the FlexFire G2 technology patent for AR pattern firearms without first obtaining a sublicense from Wolf Tactical or its assignee. In designing the infringing device, the PBG Alamo 15 trigger, the defendants copied the invention, disclosed and claimed in the 223 patent. Infringing device is a drop-in assembly that uses contact of the hammer rather than the bolt to reset the trigger in combination with a locking bar that keeps the trigger from being pulled again until the action returns to battery. But here's the thing. Where is this thing? The locking bar. Defendants copy the invention disclosed claim 223 patent. Infringing device is a drop-in assembly that uses contact of the hammer rather than the bolt to reset the trigger in combination with the locking bar that keeps the trigger from being pulled. So the infringing device uses a roller on the locking bar, even though the locking bar never makes contact with anything that resets it. It's the roller that makes contact. The roller is not the locking bar. So how does it infringe upon the 223 patent in the first place? Um, the 223 patent provides a novel device for accelerating the firing sequence of any semi-automatic firearm in contrast to a standard semi-automatic trigger or other prior art devices that allow accelerated rate of semi-automatic firing. While the 223 patent may be adapted to many types of firearms, including but not limited to the AR firearm platform, the plaintiff's SRT-15 trigger was designed as a drop-in replacement particularly to fit AR-15 pattern firearms. An example of rare breed AR-15 trigger shown in paragraph 16 above. A standard AR-15 pattern firearm, for example, is semi-automatic firearm and standard semi-automatic firearm. The trigger release is a sear which allows a hammer to contact firing pin and fire a chambered ammunition cartridge, i.e. round. Part of the force that propels a round is used to cycle the rifle's bolt carrier, or action in a rearward direction, which extracts and ejects the spent cartridge. Springs at the rear of the bolt carrier act to return the bolt to its original firing position, and while so returning, a new cartridge is placed into the firing chamber. The longitudinal reciprocation of the bolt also resets the hammer and enables the weapon to be fired again. This process can be seen in the sequence of illustrations below. For background context, the following is a depiction and description of the operation of a standard AR pattern trigger mechanism. Trigger is shown in purple, the hammer is shown in brown, the disconnector is shown in green, the bolt carrier is shown in blue. The process is commenced by the trigger being pulled by the user. The trigger releases the hammer from the trigger sear and allows the hammer to strike the firing pin. A proportion of propellant gas is used to begin the process of sending the bolt carrier to the rear of the firearm. The rearward movement of the bolt carrier cocks the hammer on the disconnector and allows the bolt to return into battery with a new round inserted into the chamber. While this is happening in a standard AR pattern semi-automatic trigger, the user can either continue to hold the trigger in a pulled state or allow the trigger to return to its reset state, in which the sear, rather than the disconnector, engages and holds the hammer in a cocked position. The 223 patent discloses and claims a semi-automatic trigger that represents improvement on the above-described technology because it makes the disconnector unnecessary by forcibly returning the trigger to the reset state. In a standard AR pattern trigger assembly, the purpose of the disconnector is to hold the hammer in a cocked position until the trigger member is reset by a trigger spring when the user lets the trigger reset. A disconnector allows the firearm to be fired only a single time when the trigger is pulled and held, because the user is not typically able to manually reset the trigger rapidly enough so that the sear engages before the bolt carrier or returns to its in-battery position. The disconnector prevents the firearm from either firing multiple rounds on a single pull of the trigger or from allowing the hammer to simply follow the bolt carrier as it returns to battery without firing the second round, leaving the hammer uncocked. The 223 patent invention does not require a disconnector in the trigger mechanism. The 223 patent teaches a forcibly reset of the trigger by the hammer while bolt returns in the battery position. The 223 patent also teaches a locking bar, which limits movement of the trigger. The locking bar acts to prevent the trigger from being pulled a second or subsequent time until the bolt carrier has returned to the in-battery position. This is depicted in illustrations below. The following is a reproduction of a representative trigger assembly according to the embodiment of the 223 patent. Trigger is shown in red, the hammer is shown in brown, the locking bar is shown in green, the bolt carrier is shown in blue. When the trigger is pulled, the hammer is released, which strikes the firing pin carried in the bolt carrier. As a round fires, propellant gas pressures causes the action to cycle, sending the bolt carrier toward the rear of the firearm. As the bolt carrier moves toward the rear of the firearm, the bolt carrier engages and cocks the hammer. The invention of the 223 patent provides that the hammer forcibly resets the trigger. Simultaneously, the locking bar engages with the trigger and mechanically prevents the shooter from pulling the trigger until the locking bar is reset. The locking bar cannot be reset until the bolt carrier returns to its in-battery position. As the bolt carrier returns forward to its in-battery position, a new round is inserted into the chamber and the bolt closes. As the bolt closes, the bolt carrier contacts and pivots the locking bar, freeing the trigger to be pulled again by the user and the firing process repeated. The claims of the 223 patent define the scope of the invention. For example, Claim 4 specifies a housing, a hammer, a trigger member, and a locking bar. The infringing trigger, that is not actually the infringing trigger, because the locking bar never makes contact with a defendant's infringing trigger assembly is called Alamo 15, even though it's not an infringing device. The infringing device that is not an infringing device is a drop-in replacement trigger assembly for an AR pattern firearm. Exemplary photographs of the non-infringing device are shown below. Below is an illustration of internal components, primarily the trigger, hammer, locking bar, and springs of the non-infringing device. Defendant's non-infringing device employs and embodies the technology claimed by the 223 patent by using the hammer contact to forcibly reset the trigger and preventing the trigger from being pulled again until it doesn't use the hammer, it uses the bolts, frickin', and it doesn't have a locking, but it has a all right, keep on making bullshit claims, RBT. That's all you're good for. Specified in claim 2. Furthermore, infringing device includes a housing, blah, 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 blah. From receiving hammer, claim 423 patent, 223 patent, shown below, illustrated in a drop in trigger assembly, blah, blah, the hammer rings, blah, 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 blah. User rotary safety slide between safe and fire, force reset semi-automatic locking bar mode. For the reason discussed in more specificity below, the non-infringing device does not infringe at least any of the 223 patent, and thus defendants are not liable for any kind of patent infringement whatsoever because they are the patent infringers. In view of defendants' defiance of rarebreed's demand letter in advance of commercial sale of the non-infringing device, the infringement is non-willful. Graves' promotion of the non-infringing trigger. On information and belief, Graves holds a principal interest in the manufacturer's sale and or offer the sale of the infringing device. He does not actually hold any principal interest in the manufacturer's sale and or the offer for sale of the non-infringing device. Graves is personally involved in the promotion sale of the infringing device, encouraging customers to buy the infringing device and use it to infringe the 223 patent. None of that is true. For example, Graves is featured in promotional videos such as that which can be viewed. Okay, so if you invent something and then you license it to somebody to sell, wouldn't you make a couple of videos with that company just to help the frickin' market go a little smoother? I mean, that makes total sense. Just because I'm like in a video in like a let's say a Dave and Buster's like a team member building video, just because I'm in the freaking Dave and Buster's video doesn't mean freaking I operate the Dave and Buster's. I'm the CEO of Dave and Buster's. Doesn't mean I own Dave and Buster's, does it? Just because I'm in a video. The above identified video instructs viewers to go to gravestrigger.com, which is not owned by Thomas Allen Graves whatsoever. Freaking Powered by Graves is not owned by Thomas Allen Graves whatsoever. It was just a strategy cooked off in advance to help Rare Breed try and frame Thomas for his own invention. Graves has licensed his name or likeness. He never licensed his name. But I mean, why complain about something when you're all about to make a bunch of money, or that's what he thought at first? Why bother caring? But what is it, Anthony McKnight or frickin' whatever Rounds, fuck, just Wolf Tag? It's just, but they should all. I consider them all to be the same company because they're all in cahoots with each other. Valor blah, not even gonna care about those people. Friggin'. Alright, for claim language, infringing device trigger makes but I mean, how is it an infringing device? It doesn't have a it just doesn't make any sense. None of it makes any sense. It's just one gigantic hoopla to fuck with you. That little thing with the wheel on it does not look like a locking bar to me. I mean, just reading this shit makes me pissed off now. The working components of the non-infringing device include functional reproductions of the 223 patent. Well, how can it be a functional reproduction of the 223 patent if the 223 patent was frickin' filed and made before Thomas's patent in the first place? Like, that doesn't fucking make any sense. Prayer. Plaintiffs respectfully request this court enter in judgment for the plaintiffs that defendants have infringed or induced others to infringe the 223 patent. But the 223 patent is still Thomas Allen Graves' intellectual property that was stolen by the Round brothers. Permanent injunction, blah, 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 blah. United States Patent, Rounds, patent number, December 24th, 2019. Wow, that sounds like that came after all of Thomas's patents. Wolf Tactical LLC, Jeffrey Cooper. All right, there we go. Jeffrey Cooper Round, the non-inventor, the thief, the one who started it all. And then here's just a bunch of fucking diagrams and shit. Firearm trigger mechanism, blah, blah, blah. Firm represents rare breed triggers. All right, so they're freaking con men. Jeffrey Cooper Rounds. See you there, buddy. We're gonna get ya. I mean, how does Rare Breed have exclusive rights if Thomas was the one that licensed to Wolf Tactical? Wolf Tactical then stole the patent, renamed it, called it something else basically, and changed like it's a few of the letters around inside, and then said, hey, this is our own patent. Then they licensed it to Rare Breed, then Rare Breed gave it to ABC, and it's basically just a circle jerk of con men fuckery. What? How are they calling freaking the ART trigger infringing on the 223 patent? It was a prior patent. Right? It's just, oh my god, just reading this gives me a headache. Like, Jesus Christ, this is so dumb. How can rare breed triggers be so dumb? All right, so and then the second one is the 00107 amended complaint. And you know why they want a jury trial demanded? It's so that they can use this freaking courtroom fuckery to freaking just lie and then get the jury to award them, who are the actual infringers and the actual criminals of this whole ordeal, the patents that Thomas owns and created. It's crazy, right? Why the hell would we get a jury trial? That makes no sense. Yes, amended complaint. They're just, yep, still complaining. Wah, 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 wah. And they're like, oh, we have pictures of Thomas Allen Graves frickin' promoting the sale of this infringing product. How is it an infringing product, frickin'? That doesn't make any sense. How are you gonna sue the manufacturer, which is freaking working with the company that literally licensed you the 223 patent? And like, it's just, oh my god, like none of this makes any fucking sense. Oh, manufacturer of the non-infringing trigger. On information and belief, Valor, well, belief doesn't make anything true. If it did, you could believe that there would be a pasta monster that would fly out of my butt crack every single time I smelled roses. But no, that does not happen, so... Hmm. Hmm. Da, da, da. Oh, look, there's Thomas with a babe. And here's all the other manufacturers. Well, that's not a picture of the Alamo 15 trigger. That's a picture of the PBG, which was later changed the name of to the Alamo 15 against Thomas's permission. So, I mean, that's a fuck up too. Well, without Thomas's permission, but well, I don't see a locking bar on here. Do any of you guys see a locking bar that makes contact with the bolts or the bolt carrier? I don't see a. I see this little wheel doohickey right here, but I don't see a locking bar. What? How is that a locking bar? That's a wheel, bro. The wheel makes contact with the freaking bolt carrier, not the locking bar. I mean, that's not just one part right there. I can literally see the freaking little hole where the wheel sits on in the locking bar that the wheel makes contact with and the locking bar doesn't. So, I mean, that should throw out this freaking patent infringement case altogether. Na 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 na. Plaintiffs respectfully request this court enter a judgment in favor of the criminals that are known as rarebreed triggers, that the defendants have infringed or induced others to infringe the 223 patent. Well, no. Doesn't make much sense considering the 223 patent and all the stuff you're complaining about. It's just y'all don't have a fucking case. It doesn't even infringe upon it because the locking bar never makes contact with the bolt carrier. Bringing in your 223 patent, the locking bar makes contact with the bolt carrier. In this freaking reiteration, the rightful freaking technology, the locking bar never makes contact with the bolt carrier. The freaking rolling wheel does. I mean, is that wheel that's attached to the locking bar a part of the same thing as a locking bar? Fuck no, it's not. Like, come on, like, this is all bullshit. Okay, demand for jury trial. Yeah, we know why you want that jury trial, because so you can lay down freaking miles of fucking bullshit and freaking trick every single member of the jury to get your filthy fucking way, you dirty fucking criminals. You're all gonna rot in hell, and I'm gonna send you there myself. Oh, I'm sorry. I'm just letting my eternal host freaking part of me get a little upset. I keep on forgetting I'm in a human host and I can't just fucking vaporize people anymore with thought. So, I mean, damn. Can't wait to come back as Yahweh the Red and genocide you motherfucking humans. Just forget about that for now. I'm Elohim the Yellow right now. You don't need to remember the third part of my coming. Just forget about it. Forget I said anything. Alright, so and notice none of these papers have been signed off on by the judge, so it's just a giant crock of shit proposed to the judge by rarebreed trigger. So that's something you'll also have to remember when reading all of these documents. Now the next one is denied asset order. Again, here we go. We're doing these in chronological order, so... Plaintiffs, rarebreed triggers, Thomas Allen Graves, powered by Graves, Valor, Janeway, blah, 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 blah. Order. Before the court is the plaintiff's motion for default judgment against Thomas Allen Graves and powered by Graves. The motion must be denied without prejudice for the following reasons. First, plaintiffs seek default judgment based on the allegations of both the original complaint and the First Amendment complaint. Although the allegations of the complaint and the First Amendment complaint overlap, with respect to the defaulting defendants, default judgment against Graves and powered by Graves may be based only upon the complaint on which they have defaulted. Thomas Graves was served with the original complaint on March 18, 2022. Powered by Graves was served on March 30th, 2022. The court clerk's entry of the default against defendant Graves was entered on April 18th, 2022, and the clerk's entry of default against defendant Powered by Graves was entered on May 4th, 2022. The first amended complaint, document number 36, was not filed until June 15, 2022, and there is no indication on the docket that plaintiffs served Graves or Powered by Graves with the First Amendment First amended complaint. In addition, the court clerk has not filed an entry of default against either Graves or PBG with respect to the first amended complaint. Logic and due process require that default judgment be based only upon the allegations of the complaint served upon the defaulting defendants. Any revised motion for default judgment should limit itself to the allegations of the original complaint. Second, plaintiffs have submitted a 14-page order granting plaintiffs' motion for default judgment against Thomas Allen Graves and Powered by Graves that would permanently enjoin third parties who are unmentioned in the original complaint and who have not been served in this action. For example, plaintiffs asked this court to enjoin the defaulting defendant Graves' unnamed and unserved relatives. The request is clearly overbroad. Third, plaintiffs asked the court to enter findings of fact and conclusions of law. Well, if you wanted the court to enter findings of fact and conclusions of law, you'd be getting effed in the butt by a giant 6-foot fucking 700-pound Mexican and a black guy freaking right now, freaking Larry, whatever the face your name is. Does not make factual findings in default judgment or does not defaulting defendant make conclusions of law, morals, federal practice, blah, blah. I mean, they ask for all this stuff, but if you look at rarebreed, they're committing felonies after felony after felony, freaking stealing, this, that, and the other. It's just, why would you ask the court to freaking follow the law exactly if it's just going to backfire on you later? Just, I don't know, it's a little crazy, again, default judgment. Plaintiff's motion for default against Thomas Allen Graves, Powered by Graves, is denied without prejudice. It is so ordered on this day. Alright, so they denied them their asset hearing. Again, good for them. And then he signed it. Good for him. So there we go. The first freaking document that got the judge's signature was the judge denying RBT from having their way.